To the latest in the Hyderabad minor gang rape case, cops have decided to seek trial of the juvenile accused as adults to ensure, they say, that they get maximum punishment. The police had announced on Tuesday the arrest of 6 people, including 5 minors. The police had said that they will be requesting the Juvenile Justice Board to recommend that the minors allegedly involved in the gang rape be tried as adults. Remember, a 17-year-old girl was allegedly gang raped by a group of boys in an upscale area of Hyderabad in an Innova car on the 28th of May. So, should the juveniles be tried as adults, especially in heinous crimes? The amendment to the Juvenile Justice Act makes for that provision in certain cases. However, it's not mandatory and there are objections to it. Joining us to discuss this today is Bharti Ali, the Executive Director of HUC, the Centre for Child Rights, and Vikram Singh, former DGP of Uttar Pradesh. Thank you very much for joining us. Vikram Singh, to you first, since all the minors in the case were booked for committing a heinous offence and that they are all aged above 16 according to the police, the JJB will first make a preliminary assessment with regard to their mental and physical capacity to commit such an offence. So should they be tried as adults?
Well, the Juvenile Justice Care and Protection Act 2000 makes clear provisions, and the amendment in 2000 clearly says that under special circumstances, youth, adolescents between 16 and 18 can be charged under special circumstances if they are old enough and have the physical and the mental capacity of an adult, commit a crime as an adult, then they can be tried as an adult. And this is one of the rarest of those rare cases where they not only acted as adults, they acted as possessed and pervert monsters. Criminal conspiracy, arranging for a car, and snaring the victim to a pub, then gang raping her. All these 4 ingredients which I have laid before you give not the impression, but a confirmatory proof that these perverts and monsters, the demons, were fully aware of what they were doing, and they entered into criminal conspiracy for the gang rape and ravished the entire life of the victim. Therefore, I compliment the Hyderabad police, and they have a very strong case to treat them as adults and convict them for gang rape.
All right, let me get in Bharti Ali. Ma'am, the amended Act of 2015, distinguishes children in the age group of 16 to 18 category as a category that can be tried as adults if they are alleged to have committed a heinous offence. If this case fulfills that criteria, what are your concerns over these minors allegedly involved in this crime to be tried as adults?
You're right that the law allows for treatment of certain cases where, after a preliminary assessment, it can be decided that they can be tried as adults. But even when they're tried as adults, the procedures have to remain within the confines of the Juvenile Justice Act. You cannot apply adult-like procedures at the cost of the Juvenile Justice Act and its principles. Besides, you cannot send them to a jail or to a prison while the matter is pending trial. They have to be kept in a place of safety, so that needs to be ensured, and a place of safety cannot be part of a jail. There are clear provisions in the Juvenile Justice Act stating that. Once the case is decided, there has to be an individual care plan in the case, So even if tried as adult, no children's court which is going to be trying their case can dispose it off without an individual care plan. And the care plan has to be monitored subsequently till they turn 21 years of age. Only that monitoring of individual care plan will then decide whether they will serve the rest of their sentence, if convicted, in jail after completion of 21 years of age, or whether they need to be released at the age of 21 based on the progress shown on individual care plan. So I think these are very important ingredients of the Juvenile Justice Act that we should not miss out on. And we must insist on that rehabilitation individual care plan, so that they don't become hardened criminals later on in life. But much depends on whether the crime can be proved.
Vikram Singh, sir, Bombay High Court Yes, ma'am, I'll come back to you. Mr. Vikram Singh, the Bombay High Court in a 2019 judgment said that Juvenile Justice Act is reformative, not retributive. The J.S. Verma committee constituted to recommend amendments had also stated, and in fact was not inclined to reduce the age of a juvenile from 18 to 16. So there are concerns over trying minors as adults.
There are bound to be concerns, but I know what I'm talking about. If these so-called juveniles have acted in the most perverse manner, would put to shame the most hardened criminals, I have my own reservations of having as magnanimous a heart as Miss Bharti ji has. Of course, compassion has to be there, but any misplaced compassion can go horribly wrong, as in this case. Compassion has to be there because it is provided within the ambit of law. And that is, of course, is one rule book that we cannot contradict. We have to follow it in letter and spirit. But I would strongly compliment what the Hyderabad police is doing to charge them as adults, ensure their conviction, and if they prove to be something worthy of being getting a lighter sentence, that of course is a far cry. I can tell you from my experience, one who is capable of doing this crime at the age of around 17. I do hope that I'm wrong, but there are very minimal chances of his improving in the course of his life. But reformation, the miracles do happen. But I would, with due respect to the Honorable Mumbai High Court, I would say that yes, one has to view things in totality. And if I were the complainant, I would have gone in appeal to the Honorable Supreme Court to get this. Reformation is one thing, and being a subject and a victim of crime is entirely another. See it with the eyes of the victim and the family. Justice Krishna Iyer has said, rape is not only the assault on the body, it kills the soul. And in this case, there are multiple assassins, and that is why I say the law should come down like a ton of bricks on them without any mercy or compassion.
All right, strong words there, Vikram Singh. Let me take that point that you made to Bharti Ali. Ma'am, you know, the argument also is made that when such a heinous crime is committed and the alleged perpetrator is tried under the juvenile justice system, which prescribes a maximum term of 3 years in a special home, is that justice to the survivor or the victim of the crime?
Well, let me make some things very clear. Number one, the police cannot decide to treat the case as a case of an adult. It is for the juvenile justice boards to take that call based on the preliminary assessment, based on social investigation report that is prepared by the probation officer. There are a lot of other facts that will have to be looked into before they can take a call on whether this child should be tried as a child or an adult. So the police has no role in it. They cannot be taking that decision at all, number one. Number two, you know, the crime is heinous, it's grave. But, you know, often we assume that the victims only want justice in their case. We deal with a lot of victims, a lot of cases under the POCSO Act. Currently, we have 347 live cases in Delhi. When you talk to the victims, they want this to be stopped. And, you know, their solutions actually lie more in a rehabilitative and reformative approach than a retributive approach. So let's not assume that every victim only wants vengeance and revenge. Victims also want to ensure that it does not happen to another girl, and that the people who are involved, if they are young enough, then our young victims also say that they must change, they must reform. The second thing I wanted to say. The third point, you know, that I want to make is that like I said, the notion that it's only 3 years, I think we need to get over and out of that. In 2015, when the law was amended, the law very clearly said in cases of petty and serious offenses, a child will be kept in custody if proven guilty, then the child will be kept in custody for 3 years. But in cases of heinous offenses, if they are not tried as a child, but tried as an adult, then they will be subjected to adult-like sentences. They cannot be sent to jail, but the sentence can be an adult-like sentence. So it can be minimum of 10 years or 20 years, depending on what offense is proven, and can go up to life imprisonment, you know, as well. So let's get rid of our assumptions which are not based on facts and understanding of the law.
All right. All right, Bharti Ali and Vikram Singh, thanks very much for joining us. I'm afraid I have to leave it there. But thank you for sharing your perspective on this story on whether juveniles should be tried as adults or not.